63. The plaintiff argued that the connection between the videos of the kind made by the defendant and the commission of a terrorist act is a real one, given that those videos identify persons said by the defendant to be a legitimate target for retributive violence. And this, I think, comes to the crunch matter as we work our way back through this plaintiff's arguments. They know they've fucked up, and they're worried now that the people will turn on them, retributive violence for the actions that they themselves have committed. They're worried that the torch burners will come out and the pitchforks will come out, when they should be more worried that there is a set of rules for the poison chalice that they took their sip from. We also have a doctor on record talking about these very specific actions, giving a reason for this retributive violence. The justice also mentions curial punishment, at which this international humanitarian law would be some sort of agreement. It's just kind of strange that earlier in this plaintiff's case they have tried to frame what would be retributive violence, or violence in return for what they have done, before then attempting to do the action of increasing what they've done under this humanitarian law, which they've admitted to on this court record very clearly through doctors' notes. They've created a situation at which retribution would be justifiable, but that retribution could come in the form of international law. 62. Alternatively, it was submitted that the defendant's conduct in publishing the videos on Facebook containing the material described above may lead to offences contrary to Section 101.5, collecting or making documents likely to facilitate a terrorist act, or Section 101.6, doing any preparation in planning of a terrorist act under the Code, particularly as the defendant is only required to be reckless as to the connection between his conduct and a terrorist act in order to establish those offences. These things, we already know that this publishing a video on Facebook is where this Detective Senior Constable Reason likes to spend his time on Facebook all day. Because here we have publishing the videos on Facebook, which would have been YouTube then linked to Facebook, allowing those videos to be shared into a Facebook environment rather than publishing them directly to Facebook. It seems as if they deemed the discussing of international war and the laws of armed conflict and asserting one's rights as a people, they saw this as a reckless connection between conduct and a terrorist act. So there's a fine line here in that to be the people you were isn't to go around blowing yourselves up. To remove a nanny is to grow up and become the son of the house. 61. The plaintiff accepted that the threats of violence are stated to only occur following the regime change for which the defendant advocates, but argued that this still satisfies the definition of a terrorist act, and while the likelihood of threatened hangings might be low, and while the defendant may have had no intention to encourage immediate acts of violence. Such threats are significant because they might create a milieu which fosters the prospect that personal injury will be suffered by innocent members of the community. And this refers to Minister for Affairs versus Benbrika 2021, 388 ALR 2021 HCA 4 at 46. The plaintiff accepted that the threats of violence are stated to only occur following the regime change. This is, the cops have accepted this point of view. The police have accepted this point of view, that the threats of violence would only occur following a regime change for which the defendant advocates. And I would argue differently, but argued that this still satisfies the definition of a terrorist act. And I think the judges pointed this out earlier in our reversal. Such threats are significant because they might create a milieu which fosters the prospect. Now this is where this creates a culture or an environment or the image of your forefathers which would not, well, I repeat, which would not advocate for acts of violence against innocent members of the community. That's just a totally benign statement. A milieu is the word that is what becomes a people within a culture that have the same ideas, ideology, but within the framework of international law can't be deemed to be terrorists because they already find standing within that international law. It was for them to stand up in it. So the judge alludes to having that a right that you can assert. And we've already seen how the police seek to undermine the neighbourhood and the community. They seek to oversee it like the state likes to look after a child. It became guardian of the people as the larger child or children. This is why little things annoy a grown-up, such as being told to wear a helmet or to slow down on your push bike. There is no need for a guardian to step in and constantly nanny the children of the state, wards of state. And we already see that the justice hinted at this class difference, which at law they have called you plebs and give you plebiscites because they see you as plebeian, at which the opposite to that would be the patrician or the landowner, at which then they have treated you as the one that is unable to inherit land, a pauper. That they haven't been able to sit down at a table and discuss or argue these matters. There are certain key matters at law at which they have failed to address at all, for fear of them discovering, I suppose, an illegitimacy at law, which would then fracture their line of authority and a right that is perceived by them. This is a difficult discussion to have because I don't have all the answers, I just have all the questions. We have questions that don't have answers, that no one's willing to sit down at a table and discuss to discover said answers, for fear that those answers might have a fracture in the belief system, and we can see throughout this whole entire matter that at the core of it becomes belief, and a foundational core that starts where this belief is in truth.